Hello, everyone. I'm just going to give another minute or two for everyone to join and sign in, and then we can go ahead and start. Thank you. Hello, everyone. I'm just going to give it another minute and then we can go ahead and start. Thank you for joining us. Welcome, everyone. My name is Romina Canessa. I am the staff attorney with the Human Rights Program at the Vnce Center for International Justice. Thank you for joining us today for this webinar, Slapped but Not Silenced, Defending Human Rights in the Face of Legal Risks. It should be a very interesting discussion. First, I would just like to briefly thank the co-sponsoring committees and their chairs, the Business and Human Rights Working Group, the International Human Rights Committee, and the Communications and Media Law Committees of the New York City Bar Association. I'd like to briefly introduce our speakers, and then we can go ahead and get started. Marie-Claude Jean-Baptiste is the director of the Human Rights and Access to Justice program at the Vnce Center for International Justice, a program of the New York City Bar Association. In this role, Marie-Claude advises clients on projects related to transitional justice, prevention of mass atrocities, and business and human rights, among other issues. Marie-Claude is also the vice chair of the New York City Bar Association's Business and Human Rights Working Group. Lady Nancy Jaramillo joined the Business and Human Rights Resource Center in December 2019 as a legal researcher with the Civic Freedoms and Human Rights Defenders program. Since then, she has been leading the global project on SLAPS at the Resource Center. Before joining the organization, Lady Nancy was a staff attorney at the Center for Justice and International Law and has been a lecturer on international law and human rights. Morgan Simon has close to 2 decades of experience making finance a tool for social justice. In that time, she has influenced over $150 billion and is regularly sought out expert on impact investing. Her book, Real Impact, The New Economics of Social Change, has been widely featured. Morgan is a regular voice in media and an active investor as a founding partner of the Candide Group, a registered investment advisor. Candide Group works with families, foundations, athletes, and cultural influencers who want their money working for justice. With over 100 investments supported and $170 million deployed, over half into women and people of color-led organizations, her firm is a leader in supporting equity and inclusion with the impact investment community. Abigail Everdale is an attorney at Davis Wright Tremaine, where she counsels and defends clients in a wide range of media, intellectual property, and First Amendment matters. She's an experienced litigator in both state and federal courts, providing representation to clients in high-profile matters involving defamation, copyright, privacy law, anti-SLAPP, reporters' privileges, and speech-focused tort claims, among other issues. Abigail regularly advises clients on their rights and obligations under the First Amendment and works closely with clients to develop internal content and speech-related policies and strategies tailored to their business needs. And last but not least, we have Marco Simons, who is a general counsel of Earth Rights International, where he has led the organization's legal work on behalf of communities around the world for more than 15 years. With Earth Rights, Marco litigates and advocates in defense of human rights and the environment, focusing especially on environmental defenders, climate change, and corporate accountability. Earth Rights co-founded the Protect the Protest Coalition to fight back against SLAPP suits. And Marco has represented advocates and nonprofits who have faced lawsuits and harassing tactics from corporations. So you can see we have an excellent set of panelists. Just a little housekeeping before we start. We will have some time for discussion after the panel. So please submit any questions and or comments you may have into the Q&A box located at the bottom of the Zoom screen. We will also be able to ask questions at the end, and I will let you know when that will be possible. And now let's get started. Marie-Claude, I'd like to start with you giving us a little context about the issue, including why it's important we're even discussing SLAPPs.
Thank you, Romina, and welcome everyone. In the United States and indeed across the world, defending human rights is an increasingly dangerous activity. Over the past years, we've seen an alarming rise in threats and attacks against human rights defenders, including murder, torture, arbitrary detention, harassment, but also false accusation and unfair trial and conviction. Human rights defenders who expose human rights violations by businesses are at an increased risk of such attacks. The civic space for defenders to raise concerns related to businesses' human rights violations is shrinking, and this is due in part to the growing criminalization of human rights defenders. It is also in relation to human rights violations by businesses that we are seeing an increase in the use of strategic lawsuits against public participation, or SLAPPs, where businesses abuse the legal system to harass defenders for their legitimate work exposing human rights violations. Out of more than 3,100 attacks recorded by the Business and Human Rights Resource Center between 2015 to 2021, attacks against human rights defenders, that is, 40% involved some form of judicial harassment. SLAPPs have a chilling effect, not just on the defenders who are the subject of the lawsuits, but on the larger community of defenders and broader society. By stifling dissent, SLAPPs threaten democratic values by adversely impacting freedom of expression and association, transparency, and accountability. Lawyers are present on both sides of the use of SLAPPs. On the one hand, they have mobilized to protect and defend human rights defenders from these lawsuits, but lawyers are also the ones bringing these suits or advising companies who do so. This is why our discussion today at the New York City Bar Association, looking at the role of lawyers in SLAPPs, is so important. The webinar is co-organized by the Vnce Center's Human Rights Program, Business and Human Rights Initiative, and the Business and Human Rights Resource Center. The Business and Human Rights Initiative of the Vnce Center works to provide pro bono legal support to human rights organizations in the business and human rights arena, and to raise awareness among the legal community of BHR. So it is BHR, meaning business and human rights. So it is only fitting that we would be organizing this discussion today. It is my pleasure to welcome you to this discussion on the state of SLAPs around the globe, including personal experiences of people who have been slapped, with the perspective of how the legal community is involved in SLAP, and more importantly, how lawyers can become allies in the legitimate work of human rights defenders. I would like to thank our colleagues at the Business and Human Rights Resource Center for partnering with us in organizing this event, and also for their great report, Slapped But Not Silenced, Defending Human Rights in the Face of Legal Risk. The report has brought to the fore the growing danger of slaps around the world. It offers important recommendations on how key stakeholders, including law firms and bar associations, can take action to stem the use of slaps. The report also highlights best practices, such as companies that have adopted a zero-tolerance policy towards slaps, and jurisdictions that have adopted legislations against slaps, including here in the United States. I very much look forward to diving more into these issues during the discussion. To conclude, I would like to thank our stellar line of panelists for this webinar, and as well as Romina for the work that she has done over the past week, putting it together, as well as the committees of the New York City Bar Association that are co-sponsoring the event, helping us simplify the message. Thank you.
Thank you, Marie-Claude. Now, Lady, we would love, I know we would all love to hear about this groundbreaking research that the Business and Human Rights Resource Center and you published recently. So I turn the floor to you.
Thank you very much, Romina, Maria-Claude, for this introduction, for the opportunity to co-organize this important webinar. The idea of my presentation is to give you an overview about the Business and Human Rights Resource Center work on SLAPs. I will share some of the findings from our global report that already Maria-Claude mentioned, and I will also explain a bit more about the context in the US, and I will end my presentation by sharing some reflections on the important role that the legal community has to play in addressing the use of SLAPs. So the Resource Center is an international organization that works in advancing human rights in business. And we have been tracking attacks against human rights defenders since 2015, who focus on business activities. And as today, we have identified more than 3,500 attacks, with SLAPs being one type of attack commonly used by business actors to intimidate human rights defenders. In 2019, based on this data, and after hearing from different partners in the field, the Resource Center began conducting a deep research on the scale and nature of SLAPs at the global level. Although anyone can be a SLAP, for instance, journalists, environmental concerns groups, and community leaders, as an international organization that works on business and human rights, our research covers criminal and civil cases that bear the hallmarks of SLAPs against people raising concerns about business operations and human rights. As part of this research, and as we already mentioned, in June this year, we released a global report along with a publicly available database with cases from all over the world, as well as a portal that centralized data about SLAPs globally. I will share the links shortly. In terms of our findings in our report, we explain that SLAPs are a global problem, and we analyzed 355 cases that bear the hallmarks of SLAPs that were brought or initiated in 2015 to May this year, but we know that there were many cases before 2015, and even there are cases that have been brought recently. So the universe of SLAPs is even bigger if we also consider that our scope is just on business and human rights. According to our research, the highest number of SLAPs took place in Latin America, followed by Asia and the Pacific, but there are also cases in Europe and Central Asia and Africa. And as I will explain in few minutes, the US is not exempt from this reality. Before going to the US context, something important that came up in our analysis is that around 63% of the cases involve criminal charges, because in many jurisdictions around the world, companies or individuals linked to them are allowed to directly submit criminal complaints before a prosecutor. I know that the context in the US is different, but in many jurisdictions, this is possible, and once it was one of our biggest findings. Now, in terms of the US, as I mentioned, is not far from the use of SLAPs. Actually, is where this concept was first coined. So our research identified 28 cases that took place in that country. Many of these cases were against community leaders, environmental concern groups, and other human rights defenders. And the sectors we identified in this country are, like using SLAPs, are aligned with the ones we see at the global level. For instance, companies belonging to the energy sector, the logging and lumber sector, or even finance and banking and other sectors such as waste disposal. In the US, the nature of the lawsuits are based on civil complaints. This is a bit different from other regions, for instance, Latin America, Africa, or Asia. And many of the arguments that plaintiffs used during these lawsuits are based on defamation, libel, slander, and racketeering. In general, in our report, we argue that SLAPs masquerade as an ordinary lawsuit, but in a sense constitute an abuse of the legal systems. The plaintiffs are not intent to win, but to intimidate human rights defenders. So this is one of the main features of SLAPs. As probably many of you have read, the SLAPs can have significant effects on those working in the public interest. In our report, like the ones working on business and human rights, and those effects include slowing their work or draining their resources, first because defenders have to pay for the legal representation, but also because many of the lawsuits involve huge amount of damages. So mainly in cases related to civil lawsuits. And something also very important that we analyze in our report is that usually those kind of lawsuits came after the human rights defenders have expressed a critique of business actors by publishing a report, participating in an event or interview, launching a campaign, organizing a demonstration, or even just posting on social media. So this is something also very important to analyze. Just to finalize, I would like to share some reflections on the role of the legal community to address the use of SLAPs. Maria Claude already mentioned a couple of things, but also in our research, we were able to identify 19 law firms and lawyers that represented companies in those lawsuits. Nonetheless, in many cases, the information was not publicly available, but for the ones we identify, we also see that many of the law firms or lawyers were involved in more than one case. So we can even argue that there are some law firms specialized in bringing SLAPs, and this is why it's so important to have in mind the important role and the responsibility that the legal community has to fight this kind of tactics, even because these tactics are also being normalized by the legal community, since there is a narrative about being aggressive through the use of the legal system as admirable. At least in my region, Latin America, this is something very common, like the brave lawyers and the more important lawyers are the ones that are using the legal system in different ways, even if this means attacking human rights defenders. So this is why it's so important also to work on that narrative, and also it's crucial to involve the legal community, not only by educating on human rights standards, but also involving them in different ways to support human rights defenders, for instance, by providing pro bono legal support for different matters. I will end my presentation just by saying that in our report, we provide several recommendations to companies, investors, and government, as Maria Claude mentioned, but we also said that it's important that the legal community refrain from representing companies in SLAPs, and they should ask themselves if they are handling cases that could bear the hallmarks of SLAPs, just to avoid representing them. So I will stop here and looking forward to the discussion. Thank you.
Thank you, Lady, for that excellent overview. And Morgan so kindly put the link to the report in the chat, which you should all be able to see. I encourage everyone to read it. And speaking of Morgan, now I'd like to turn to you. I think your case is particularly interesting, because I know many people tend to think of SLAPP cases as related to only land or natural resources. And as we just heard from Lady, many of the cases in the US are related to these sectors, but that obviously isn't the only type of cases, of SLAPP cases that we have. After writing extensively about the link between banks and private prisons and immigrant detention, you and the Candide Group were sued by a private prison company for defamation, and the case was ultimately dismissed last year. So as someone who has personally dismissed and is now being appealed, I believe.
Exactly. It's not over. It's decidedly not over. But yes, we did win round one.
Round one, and I'm sure, I hope, it's the last round after this appeal. But I'd love to hear more about as someone who has experienced being slapped, both personally and your company as well. Could you talk a little bit more about the harms caused by slaps, both to individuals, directly defending themselves, but also in the broader sense? I know Marie Claude alluded a little bit to that in her remarks, but we'd really love to hear from you as well.
Sure. Thank you for having me. And I think this is the first time that I've really spoken publicly about, it's interesting as I hear the phrase, "you've been slapped." It really does have that sort of violent feeling to it in terms of the pain that it causes. So I appreciate that this is an issue that the legal community is paying attention to. I wanted to take a moment to just share what the case is. I thought that might be helpful, and then what my personal experience has been. So I want to start out by making this very controversial statement that apparently caused as much as $60 million of damage, which was that prisons separate families. And I don't know if you know anything about prisons, but typically when a person goes inside one, right, whether it's a cell, a cage, a jail, a prison, a family detention center, they are de facto separated from their family. And in the context of the family separation crisis, there were over 5,000 children that were ripped from the arms of their parents. And it's still, very emotional because there's over 500 children that remain separated from their parents. And as an activist, that's where I want to be focusing my energy, is reuniting those children with their families and not on fighting a lawsuit. And that really is a major purpose of SLAPP suits, is to try to distract attention from the real issue. Because I wrote as an activist an impact investor in the pages on Forbes.com, where I'm a senior contributor, that prisons separated families, because during the family separation crisis, they did. And that's the truth. And I was happy to see that recently confirmed in a number of amicus briefs that were filed, including by over 30 major news organizations, from the New York Times to Fox News to Forbes itself, that essentially what I was writing was truthful in terms of the role of private prisons in the family separation crisis. And that this reality was not lost on over 500,000 people across the country who were looking, kind of following the money with respect to family separation, and the fact that major banks that we all know and love, from Bank of America to Wells Fargo, were financing the private prisons that were profiting from family separation. And you had over 500,000 people across the country who signed petitions, did in-person actions, essentially saying to the banks, we don't want to make money for our families by separating someone else's family. And these voices were incredibly powerful and successful, that close to 90% of the financing community to private prisons said that they would no longer support these harmful contracts. And that apparently caused some financial hardship for these prison companies that they essentially tried to pin on me and on the activist work that we were a part of. And what I would say is that the truth is what caused that, right? To some degree, as an investor, I would say the market worked perfectly here, that consumers saw that companies were participating in damaging, terrible behavior, and they ran away from those companies, right? They showed that there were consequences on the market when companies are not being socially and environmentally conscious of what they're doing. So that led to this lawsuit, that activism. I was asked to talk about what that experience has been. And I would say as an activist, we don't usually talk about that, because the point is that as movements, we really are trying to be as strong as possible in the face of so much tragedy that's out there, and recognizing that my worst day dealing with this lawsuit is still better than anyone's best day in a family detention center. And that's what I have to keep really firm and present in all the work that we do. I would say that the two worst days that I had in this process, one was waiting for the judge to give their ruling and walking around my house, wondering if I was going to get to keep it, keep my business, keep everything that I've built. The reason I'm generally able to disconnect from that fear is because I have great legal counsel. And that the month before I had that established, I was terrified. I was terrified. I knew I would break down somewhat on this webinar. I was prepared for that, but apologies that it's, just taking time. That, we were lucky that we had insurance, but that explaining the complexities of this case, that we couldn't just call any lawyer from a billboard, right? That we needed to make sure we had really thoughtful, specialized counsel, that a lot of the pathways in terms of seeking support are pretty challenging. And that it really took a lot of cajoling and begging and process to be able to get to the point we are now, where I have such fantastic legal partnership from Davis Wright Tremaine, and really want to thank Abigail and Tom Burke and the whole team there that's been just so phenomenally supportive, both in terms of legal process and also through emotional support, of recognizing that part of going through this process is you do have to hold the fear and the pain that essentially the defendant is holding every day. So from that perspective, knowing that more legal counsel is aware of these issues, particularly the fact that over half of these cases, as found in that business and human rights report, are in the global South, that there's so many cases where people are facing criminal charges it's one thing for me to imagine getting kicked out of my house and put onto the street, but quite another to think I could land up in jail. And just knowing how critical that defense is, how absolutely impossible it is to do that on your own, that the extent to which people are willing to take up these cases. I think what I learned through this experience, and the piece that has been really powerful to me, is that regardless of whatever issue you care about, whether it's the environment, whether it's family separation, I think a lot of us care about a lot of these issues. If we don't have free speech, we lose on all of these. If we don't have the opportunity to be able to debate perspectives, like that is what has always made society great. And if we can't even protect that right, then we are in so much trouble. And from that perspective, I'm always happy to speak to our case if it can help advancing that cause, if I can help encourage other lawyers to get engaged. So thank you for your time and consideration and listening today. And as was mentioned in the beginning, we still have some fight to go in terms of the appeals. And I'm very, very hopeful that the truth will set us free as it should. So thank you.
Thank you, Morgan. Thank you so much. We are honored that you have, chosen this forum to share your experience. And, we are also, I know I'm speaking for everyone, that we're also hopeful going forward. As you said, if we don't have free speech, what is left? I thought what you said about having fantastic legal partnership was incredibly impactful. So, I'd like to turn to Abigail to hear more about SLAPs from a lawyer's perspective and how you bring about that fantastic legal partnership. What can lawyers do to address SLAPs? What is the role of a lawyer in this? Speaking to the legal community here.
Yeah, so I mean, there's two sides to this. There's one as a lawyer for a company who's considering bringing a SLAP, but I think this is an incredibly important panel to try to encourage people to not do that, because it is incredibly damaging, especially when these actions are brought against individuals, activists, people who are using all the means they have to fight these social battles. This is not something that is a good use of time and emotional resources, financial resources. It's very damaging. But my side is to work on defending these kind of cases. So first of all, in terms of forming this relationship, I have to give all credit to my partner, Tom Burke, who was the person who Morgan reached out to initially and who got into this arrangement. I came in a little bit later on to support. And Tom is based in San Francisco and is sort of the preeminent SLAP defense person there. He wrote the book on how SLAPs work across the country, and is really, on the forefront of all these things. But we were, I suppose, lucky in a way, because this case was filed in California in federal court. And California was one of the first states to enact an anti-SLAP law. Now there are 31 states in the District of Columbia that have anti-SLAP legislation, and it's incredibly meaningful. And in California, it's especially meaningful because in California, these laws are available in federal court as well as in state court. So the Ninth Circuit a long time ago made clear that the California anti-SLAP legislation was, even though highly procedural in the way it functions, and just to step back a little bit, the California anti-SLAP legislation essentially provides for a number of upfront procedural protections to defendants in SLAP litigation. If these defendants can prove that the action is a SLAP, which involves a showing essentially that the action arises out of your free speech on a matter of public interest, or your use of public participation, your constitutional rights, speech-related rights, and rights of public participation, which can involve petitioning the government, a variety of things. But the places you see it most are in essentially free speech, so publication of statements. If you can prove that it's a SLAP, then you get a number of procedural protections. You get a sort of burden shifting framework where the plaintiff has to make an initial sort of fairly difficult showing that the case has merit. You can get a stay on discovery. Discovery can be one of the most, if not the most expensive part of litigation. So that can really, really help defendants from not engaging in unnecessary expense. You can have interlocutory appeal, which basically means if you lose at the first stage, you can take it straight to appeal without having to continue with the litigation while waiting for that appeal. And the most important provision is that you get attorney's fees. So if you win your case, you can seek your fees. And that is really the teeth of any anti-SLAPP statute, is the attorney's fees provision. Because it not only provides SLAPP defendants with an opportunity to make themselves whole financially, at least. So as you know, you can tell from Morgan and from anybody who's been subject to one of these things, you can never get back the time and you can never get back the emotional energy. At minimum, you can get back the money you've had to spend on this. So the attorney's fees is the most important part. And the other thing it does is it discourages SLAPPs in the first place, because knowing that if you bring a litigation and you lose, you have to pay fees discourages meritless suits, where a company may decide if they really want to chill speech on a certain topic, they may decide to bring a case with questionable merits simply to show that they can force you to spend money if you talk about this topic. So they really do, and they can have a very chilling effect on speech. Even in the United States, where we don't have criminal defamation laws, where we have some of the strongest First Amendment protections in the world, if not the strongest. Not saying that everybody doesn't try to silence speech anyway, but those provisions are really the key. One trouble we face is that not all federal courts believe that SLAPP legislation is necessarily available. Outside the Ninth Circuit, a lot of federal courts have determined that it's procedural ultimately, so you can't bring an anti-SLAPP motion in federal court. So really, the primary place you're seeing these play out is in state court. Hopefully, that will change. And in the Ninth Circuit, at least at the moment, you can get your attorney's fees back in federal court, and that's what's being really challenged on appeal in this case. The plaintiff in this case, the private prison company, is represented by a very experienced defamation plaintiffs counsel, and they would love for anti-SLAPP laws to not be available in federal courts. So they're challenging that and trying to get that changed. But in the meantime, on the state court level, anti-SLAPP statutes are really the best protection that we have. And, you know, 31 states plus DC is great. It would be great if we could have 50 plus DC. So supporting anti-SLAPP legislation. You know, in New York, we had anti-SLAPP legislation in 1992. However, it only applied to a very narrow category of public participation, which included things like applying for permits. So if you got sued over the permit application process, you could bring a SLAPP action based on that. And as you can imagine, the statute was very, very rarely invoked. There is a handful at best of case law of anybody invoking the statute. But about a year ago, in November 2020, the statute was amended and now provides similar protections to the California statute with attorney's fees, procedural protections, and heightened standards. So if we can do it in New York after all this time, you know, we can do it in a lot of other states as well. And I encourage any of you who are outside New York to you know, help these things pass. The other question is how to deal with SLAPPs outside of just being able to rely on SLAPP legislation, anti-SLAPP legislation. And what we do at our firm is a lot of pre-publication review. We work for media companies. We also work for activist organizations, routinely work for companies like Greenpeace and Global Witness and other organizations that are doing human rights reports. And we do in-depth pre-publication review to try to make sure that if lawsuits do arise from these reports, those lawsuits are, the cases are tied up with a bow. There's nothing that can come through that there's nothing questionable in it at all. And, you know, that's upfront work and it takes time and it takes money. But when you know that what you're doing can really be a target, it's really worth doing. And then on the other end, you just defend as best as you can, I suppose, and try to hope that you can take advantage of these legislations and try to hope that the law, which has a lot of protections built in on the basis of the First Amendment, will provide you an opportunity to get things dismissed before they go too far. And that's what we try to do every day, essentially.
Thank you, Abigail, for your perspective on that. I know that there were several New York City bar committees that advocated for the amendments to the New York State anti-SLAPP statute. So I know everyone at the city bar was very happy that those amendments were approved, and hopefully, as you say, we can get the remainder of the states on board. Marco, I'd like to turn to you. As general counsel of Earth Rights International, you're very experienced in also defending advocates and organizations against SLAPPs. And I'd love to hear a little bit more from your perspective about what you think the human rights and ethical responsibilities of lawyers are with respect to SLAPPs, and if and bar associations as well. Be very interesting to hear. Don't think we can quite hear you, Marco.
This,
Yes, now we can hear you. Thanks.
you hear me now?
Yes.
Okay, great. So it's a pleasure to be here. Thanks to the organizers and sponsors of this panel. It's a great lineup and a privilege to be here. I want to talk about a couple of things in terms of responding to SLAPPs. I agree with Abigail's points in terms of the importance of anti-SLAPP legislation, but I also think it's necessary to take that up at the federal level as well, both for federal court, but also because I believe, because this concerns First Amendment protections, that Congress could actually prescribe procedures that would apply in state court as well, or a removal provision from state court to federal court. And the reason for that is because defendants have a strong incentive to forum shop, right? Or plaintiffs, sorry, SLAPP plaintiffs have a strong incentive to forum shop and find a jurisdiction that doesn't have any anti-SLAPP protections in order to bring their lawsuit. So we really, this is the First Amendment we're talking about. We really need a national standard here. On the other hand, it does need to be narrowly drawn or appropriately drawn so that it doesn't sweep too much, other conduct in. My first sort of touch with anti-SLAPP legislation, California's law actually, was when we sued Chevron for human rights abuses against communities in Nigeria and lying about it, and they responded with an anti-SLAPP motion. They did not win that motion, but in any event, these motions can also be weaponized by corporations engaged in human rights abuses as well in some contexts. One other thing I'll mention just briefly is, personally, I think that the number one thing that needs to be done in order to deter SLAPP suits is not on the legal front at all, but it's actually ensuring that this is not a successful strategy in the sense that the activists, folks like Morgan, are actually supported in doing their work. And so I know this is mostly a legal audience, but if there are, advocates and activists and funders in the audience as well, I think the number one thing to do is to ensure that the underlying campaign that is engendering the SLAPP is not only not diminished by the filing of a SLAPP, but is strengthened and hopefully successful. And so that this strategy is not successful, not merely in court, because these suits usually aren't filed with the goal of being successful in court, but that it's unsuccessful in deterring the underlying campaign that the SLAPP plaintiff is trying to silence. With respect to the legal community, though, in addition to supporting anti-SLAPP legislation, I think there's a couple of things worth talking about. One is, I think as Morgan and Abigail demonstrated, we do need lawyers willing to take on these cases. And especially in places where either insurance coverage or potential fee statutes are not available, attorneys willing to take these cases on pro bono, to give folks like Morgan the sort of peace of mind that they do have a defense here, and that this does not distract them from their other valuable work. So if anybody is interested in joining this, I'm going to put a link to the Protect the Protest Coalition, and you can, there are links there to to sign up to assist with SLAPP defense in appropriate cases. There's also been discussion at various points around the sort of ethical responsibilities of lawyers involved here, and whether there should be a stronger approach by the bar taken against attorneys who are filing frivolous SLAPP suits. I think that the existing rules do cover some of these cases where the suits really are frivolous. And so it might be worth looking at action there. And occasionally you do get sanctions against attorneys as well for bringing these suits. I want to be careful about that though, because SLAPPs in many cases are a manifestation of existing power dynamics. And for better or worse, bar sanctions are also often a manifestation of existing power dynamics. And so those of us in the human rights and public interest communities may find ourselves just as likely to be on the receiving end of sanctions for what somebody believes is a frivolous suit, as we are to successfully use these to deter SLAPP suits on the other side. What I think is also worth thinking about, though, is the what I might refer to as social sanctions against this kind of behavior. There's sort of a widespread belief in at least the American legal community that it's improper to criticize a lawyer for the tactics that they take on behalf of clients. And the blogger Duncan Black has satirized this as the notion that it is unconstitutional in the United States to criticize lawyers. Now, that's not, of course, actually true, but there is a strong principle underlying the notion that at least in criminal cases, criminal defendants should be able to obtain legal counsel to defend against, state prosecution without having that, counsel be necessarily associated with a criminal's actual or alleged misdeeds, because otherwise it would be very hard for criminal defendants to find counsel. But that principle has gone way beyond the original purpose of it in that context. And in fact, I would posit that in many cases where you have counsel for SLAPP plaintiffs representing extremely powerful interests, that their ethical roles should essentially be more akin to those of a prosecutor, who has a special duty to justice and not just to make all available arguments on behalf of their clients. There isn't actually anything in the rules of professional responsibility that says lawyers can't be criticized or the imputed conduct for the legal strategies that they pursue on behalf of their clients. The rules say this is in New York, it's Rule 1.2b, that representation of a client does not constitute an endorsement of the client's political, economic, social, or moral views or activities. But it doesn't say that lawyers, don't, can get a free pass on the legal strategies that they pursue on behalf of a client. And lawyers shouldn't get a free pass on that. When we allow sort of high-profile lawyers and law firms to, receive awards, to have high standing within bar associations and socially generally, while pursuing these kinds of tactics, we're undermining faith in the legal profession generally. And so I would encourage everyone to not fall into this trap of allowing attorneys who pursue somewhat odious tactics, regardless of whether they are formally considered frivolous under the legal or ethical standards, of allowing them to maintain a high sort of status within the legal community. There's no reason for that. Lawyers should face opprobrium for pursuing these kinds of tactics, which are at their heart designed to suppress, First Amendment's rights. And in fact, the rules of ethics say that lawyers can't take a case merely for the purpose of harassing any person, and that they're supposed to withdraw if that becomes apparent as the object of the case. It also provides that lawyers may withdraw whenever the client insists on taking action with which the lawyer has a fundamental disagreement. So lawyers are entirely free to decline representation or even withdraw from representation simply if they disagree with the client's positions and activities, including the legal strategies that they want to pursue. And we need to get away from this notion that every civil litigant, especially powerful corporations, have the right to any lawyer of their choosing to pursue any strategy that the lawyer thinks might not get them sanctioned in a court of law. That's not where the rules of ethics are, nor where our social mores should be.
Thank you, Marco. I think I'd also say, in addition to the rules of ethics, I think the UN guiding principles, which I would argue also apply to law firms and bar associations, also outline this responsibility for lawyers and law firms to avoid taking these types of lawsuits. Before I open up the floor to questions and comments, please, if anyone has any questions or comments, submitted in the chat box at the bottom of your screen, or raise your hand, also available at the bottom of your screen. I'd like to ask the panelists if there's anything else that they want to add, or any comments that they didn't have a chance to raise earlier.
There's two things that I'd add. I really appreciated, Marco, what you were saying at the end of kind of the moral obligation to choose how you spend your time, what cases you take on. And it makes me think of how architects have come together to say that they won't build solitary confinement cells because that's torture, right? And they don't want to participate in torture. I think there's many circumstances, particularly these activists who are getting all sorts of criminal and civil charges, that's essentially a form of persecution and close to torture in terms of the loss of liberty. So the extent to which that becomes part of moral considerations, I think, is extremely powerful and important, and ideally for the legal profession to take a proactive stance in saying that we do not want to be part of persecuting activists and persecuting free speech more generally. Second, which I put into the chat, it is a good point that Marco made, that oftentimes activists don't know what we don't know in terms of the need for legal review. And that's now something that we are, getting much more strict about, but we really could use help. So we generally look to counsel to review writing before it goes out, a couple hours a month. It's not that many pieces, but if there's anyone who might be interested, I put my email in the chat, morgan@candidegroup.com, and would love to share a bit more about the work that we're doing and ways to support moving forward. So thanks, everyone.
Thank you, Morgan. Great, we have a couple of questions. So from Luke, and I open this up to anyone to answer, what role can the judiciary play in evaluating SLAPP suits that land across their docket? Abigail or Marco?
Dismiss them. State laws vary widely, and in certain states, it's much harder to get these cases dismissed. Under New York law, there are privileges and a lot of pleading standards and very strong protections that you can apply as a judge to dismiss these cases at an early stage. And there's precedent and there's law saying that it is not only fine, but appropriate to dismiss cases like this at an early stage when they target protected speech. And that law is clear, and it's just a matter of sort of seeing a case for what it is and applying the law that exists. Because we didn't have an anti-SLAPP statute for a long time, the judiciary felt obligated, and rightly so, to make sure that there were protections to get cases dismissed before discovery, because judges understand that discovery can be the worst part of a case. That's not true in all states. There are some states where you'll file a motion to dismiss and they'll say, well, let's go ahead and complete discovery before I decide the motion to dismiss, without any idea, without any concept that that's incredibly damaging. But in New York, the protections exist and the law is clear, and it's really just a matter of spotting these cases for what they are, which is frankly not too hard when you look at the facts of the case, you look at the publication at issue, you look at the parties. It can be fairly straightforward to spot them.
Thank you.
Yeah, I would echo what Abigail says, and I would say that with the exception of like attorney's fees, for example, a lot of the procedural protections that anti-SLAPP statutes provide, judges could implement on their own as a matter of their own case management. So even in the lack of an anti-SLAPP statute, they can do a lot of this themselves, and they should.
And perhaps part of that is educating the judiciary on the harms of these types of statutes, or I'm sorry, on these types of lawsuits. Another question we have is how do we raise awareness of the general public of SLAPPs? So there's social and economic costs for those who use SLAPPs. The legal intricacies make it difficult to discuss SLAPPs with a non-legal audience, and I would argue that many people, including educated investors and educated public, are unaware of these types of lawsuits. So, do you have any ideas how we can bridge this gap?
I don't know that there's an easy answer to that. We as lawyers are not necessarily the best PR people. In fact, I would say the activists are probably much better at it than we are. But I will say anecdotally, having worked in the media industries for a long time, it's always been a bit of a double-edged sword in trying to get anti-SLAPP statutes passed, because they have broad support from the media, but the media going out and saying you should pass this anti-SLAPP law in the wrong climate can actually be damaging rather than helpful. It really depends on who the legislature are and who they're answering to. So it's been challenging. I mean, in New York of all places, to have only gotten an effective anti-SLAPP law in place a year ago should be surprising in a state that is the primary state for the publishing industry. And it's a little bit about that. It's a little bit about the disconnect between the legislature and the media industries. So it's a really good question, and frankly, a challenge. I wish I had a better answer.
Morgan, as an investor, I'm asking from your investor perspective. I know in June of this year, a number of investors signed on to a statement urging companies to ensure that they don't use SLAPPs. How can we get more? I don't know if you have any ideas how we can appeal more to the business community on this as well.
Sure. Yeah. And it's a piece that I kind of glossed over a bit. It's funny that I'm a senior contributor to Forbes.com, but the Forbes network is really kind of experts writing about what they know, right? Very different than traditional journalism. So it's really a tiny part of my day. And most of my time is investing in companies and funds that are, changing the world, essentially focusing on the positive side of what we can build. So utility scale solar for the Navajo Nation, or fair trade cacao, or, these sorts of things. But then we also try to help activists of how do you use money as a tool for social change. And that's even how we got involved in family separation, of members of the Families Belong Together coalition, like Presente.org, which is also part of Protect the Protest, coming and saying, hey, we think there's a money story here. Can you help us figure that out? So that's how these pieces kind of intersect. And I think from that investment perspective, one of the things that is fascinating to me about my lawsuit and about SLAPP in general, at a time where, for instance, in the case of private prison companies whose stock had fallen by over 50% over the course of a year, and you're going to take hundreds of thousands of dollars and invest it in a frivolous lawsuit, right? Like, that's just a stupid use of shareholder money, in my opinion, right? If I was a shareholder, I would find that abominable. So I think there's an interesting issue in terms of publicly held companies that are accountable to investors. Where are they investing their available cash? And if it's investing it in these highly risky, I would say, lawsuits, where they're quite likely going to wind up having to pay legal fees on both sides, as an investor, I don't even have to care about the fundamental issue. I'm just going to see that as a bad business decision. So I think that's important to highlight as well.
Great. I would agree. And Abigail, I have one last question directed to you. Are there U.S. government organizations or departments who partner with you or support the work you do in private practice?
U.S. government organizations?
Yes, the question specifically says government organizations. I'm assuming they mean government departments. I don't know if Mandy, you'd like to clarify that.
I would say probably not. I can't think of anything off the top of my head.
Agencies that protect the First Amendment.
Oh, for First Amendment protections. We have certainly, our interests have certainly converged with organizations like the Attorney General's office in New York and other government agencies. We at Davis Wright Tremaine, we've done some work on behalf of government agencies that are responsible for regulating advertising in public places. But other than that, no, this is something that we do as a private practice matter. There's a great deal of pro bono built into the work. But for the most part, you know, our clients tend to be media and publishing companies that have the expense of legal representation built into their business model. And it's not insignificant. It's a major thing to have to build into your business model and to get insurance for and to make sure you're getting coverage for, which is why it's always such an enormous concern when these kind of lawsuits target individuals, social justice organizations that don't necessarily have this financially built in, because it can be incredibly harmful. But no, to answer the original question, it's not typical for us to partner directly with government organizations on these kind of things.
Thank you. And I'm sorry, we have come to the end of our time. I know there's a couple of questions we couldn't get to. I think we've had a very interesting and fruitful discussion today. You know, as we've heard directly from Morgan, SLAPs have a significant adverse impact on individuals and on the work of activists and human rights defenders and others working in the public interest, including slowing down the activism and deterring these campaigns, draining resources, and most importantly, in creating a chilling effect on the freedom of expression and on legitimate human rights work. You know, one important step in addressing this problem is raising awareness, as we've discussed. There's also a need for others, as we've heard, especially the legal community, lawyers, law firms, and bar associations to take action. And these can range from supporting anti-SLAPP legislations and also, you know, pro bono work, as we've heard, to defend activists or support in things like pre-publication review. I'd like to thank all of our speakers and in particular the Business and Human Rights Resource Center. I encourage everyone to read the report on SLAPs, and thank you to everyone that joined, and to the New York City Bar and to the co-sponsoring committees. We will be posting the recording along with some of the additional links and resources shared in the chat on the Vnce Center and the City Bar websites. And I hope everyone has a good afternoon. Thank you, everyone. And I'd just like to ask the panelists to stay on for a second so we can take a quick screenshot if that's okay. One more. Great. Thank you so much, everyone. It was a pleasure. Pleasure meeting you all.
Thanks, everyone. Thank you, Romina.
Thank you.
Thank you, Romina.
Thanks so much, Romina.
Thank you, everybody. Bye-bye.
Bye.
Take care.
Thanks.
Bye.